Hi, hello, and welcome to this Kingsfield Academy webinar. Some of you may have called into these webinars before, but for those that haven't, my name's Carl Haynes and I'm a partner at Kingsfield Academy. I'm joined today by my colleague, John Fotherby, also from Kingsfield Academy, and Alex Johnson of Freeths LLP. So just again, for those people who haven't been in on these before, Kingsfield Academy, we're a leading training and coaching provider, and we offer pragmatic solutions around commercial, contract, risk, change, claims, time management, all embedded within project leadership and stakeholder management. And this is purely to the engineering and construction industry across all levels through the supply chain. A little bit about Freeths. So Freeths is a top 50 law firm that's based in the UK, and they have a dedicated team of specialist construction and engineering lawyers who advise their clients all over the world. And since March, Freeths have been advising their range of clients on implications for their projects arising from the COVID-19 pandemic. Alex, who joins us here today, is a partner specializing in engineering construction disputes avoidance and management, and has some experience of working on some of the world's largest engineering construction projects and the issues that affect them. So I'm very grateful for their time today to help us with this webinar. Just to give you some understanding of what we're doing in this webinar, this is the first in a series of 3. I know Kingsfield has been doing webinars on COVID-19 now for a number of weeks, but this is its own subset of 3. Starting today, John and Alex are going to be talking around, where we are today, and actually where are you today on your projects? What are you experiencing? And to help those discussions, we're going to be using a case study scenario, which hopefully you will have received along with your when you registered for the event or downloaded from our website, and you will have read that, but never mind. If you haven't, I'm gonna read through that shortly just to give you an outline of what the case is. So that's what we're doing today. The second webinar, which will be on the 21st of this month, is going to continue on from our discussions today, but moving into making and defending cases. And then the third one, which is going to be on the 4th of June, so we're going to give you a week off to consider things. We're going to be talking about getting to yes. So how can we get to yes with hopefully avoiding disputes? So hopefully that's of interest, but let's continue talking about today. So the duration of the webinar is for 60 minutes. 45 minutes of that hopefully is going to be John and Alex discussing the scenario, the case study scenario, and the events that occur within that scenario. John's going to be providing the kind of practical perspective on this, and Alex is going to be providing the legal perspective on this. So some interesting perspectives to be drawn out here of all the events. And then hopefully we'll have 10 minutes at the end for questions. So let's move on then. Oh, I should also say that we have Wayne Edmonds from Kingsfield Academy in the background running the webinars and doing the polls and funneling the questions through to myself, which you can type in through the question box, not the chat box, please, into the question box, and then Wayne can funnel those through to me. And generally, Wayne's just there to make us look good. So let's see if he can do that well. And Wayne, if you could just bring up the first poll for me. So I'm really interested to see who we've got in this kind of virtual room. And so if you could just kind of vote on which category best suits you, so owners, contractors, subcontractors, vendors or suppliers, consultants or advisors. So if we just leave that up there for a little bit. Just while you're posting your responses, I just want to point out that you probably noticed that this webinar is being recorded. the purpose for that is for anybody who misses it, we can then post it up on our YouTube channel afterwards. So if you want to look back on it, or if you want to refer it to a colleague or friends, then you can direct them to our YouTube channel, and that should be up there within the next few days. And also Freeths will also be hosting it on their website too. So okay, so we seem to have a lot of contractors, a small number of owners, not so many in the vendors suppliers range, but we've got a mix of almost everybody then. Okay, so that's excellent. Okay, so I realize I'm buying up some essential talk time here. So what I'm going to do quickly, for those of you that haven't managed to read through the case study, I'm going to briefly cover through what was sent out, just to give you an understanding of what it is we're talking about, and then I shall hand across to our experts here today. So without further ado, the case scenario. So the background of the case is that the owner is a public quoted utility and is constructing a major extension to a sewage water treatment plant serving a large European city. The EPC contractor comprises of a three-party joint venture between 2 European companies and 1 Asian company, and is engaged under a bespoke EPC lump sum turnkey contract specially developed for this project. Construction is being carried out by European specialist trade subcontractors engaged by the EPC contractor, and procurement is being carried out under a global sourcing policy. Now, in February 2020, reported progress was as follows. Engineering planned was 85%, actual was 75%. Procurement planned 70% and actual was 60%. And then construction planned was 28%, but the actual was 20%. So let's talk about COVID-19 and the EPC contractor's reaction to this. So in mid-March 2020, the government imposed a lockdown on existing emergency powers and advised all people except essential workers to remain at home and wherever possible work from home. So there was no specific government direction or advice to close construction sites. 24 hours after the government lockdown and its stay-at-home advice, the EPC contractor, without warning or any form of contractual notice, closed the site and barred all people, including the owner's people and subcontractors, from entering it. The EPC contractor said later that this was to comply with HSE regulations relating to COVID-19, but there is no recorded incident occurring on the site. The site remains closed, although a rumor suggests that the EPC contractor may be planning to reopen it. Okay, finally, let's talk about delays here. Under the delays, the major pumps are being procured from Asia. These are on the critical path. In February 2020, there was a reported delay to delivery of 3 weeks. The vendor has declared force majeure under its purchase order with the EPC contractor because the factory has been closed due to COVID-19. It has provided evidence documenting the factory closure. The structural steel is being fabricated in Europe under a direct contract with the EPC contractor and will be erected by a subcontractor local to the site under a subcontract with the EPC contractor. Steelwork erection was due to commence in mid-March 2020. The steel fabricator is procuring the steel from India. The Indian vendor has declared force majeure under its purchase order with the fabricator due to COVID-19, but has not provided any details to demonstrate that manufacture has been affected by COVID-19. No prefabricated steel has yet been delivered to the site. The EPC contractor, through its Asian partner, planned to mobilize construction supervisors and other on-site management personnel starting in March 2020, but has been unable to do so because of travel restrictions in the country of origin by government decree in response to COVID-19 in the country. So that is your case study today. So what I should probably do now is stop my own talking. I guess let me bring John into the conversation here. So John, perhaps you can take us through what might be the drivers for the EPC contractor closing the site, and what might be the risks for the EPC contractor of taking this action? Over to you.
Okay. Thanks, Carl. Good afternoon, everybody. Before I go to Carl's question, I think there's a point to be made that in any situation like this, the contractor has got to have the powers under the contract, whether that's regarding force majeure or suspension or whatever action he wants to take. He's got to have those powers, and secondly, he's got to be able to comply with them. So that's a sort of background. But going to your questions, Carl, I think the drivers are primarily economic. And if we look at those, first of all, minimizing the cost by not keeping resources at the site. Secondly, avoiding potential disruption productivity claims from his subcontractors and vendors due to the circumstances of COVID-19, social distancing and all this sort of thing. Limiting the uncertainty regarding work performance. It's going to be very difficult to know where we are with progress, resource availability, and utilization resources whilst this COVID-19 exists around. We then come on to when the job wants to restart, there's probably going to be a messy situation on site because of the lack of progress, on resources being used quite unplanned, etc., etc. So once it's returned to normal, it's going to be a bit difficult to sort out where to go. So all of these things are probably fairly pragmatic from a contractor's point of view to minimize cost and safeguard the situation as best you can. But they also may be regarded as a little bit short term, and in the longer term they may be somewhat counterproductive. So Carl mentioned risks for the contractor in this situation, having decided to close the site. First of all, that decision would need some fairly careful thinking about, because there are practical and legal contractual issues to take into account. And if we look at the case scenario, it looks as though that was not really done in any great or sufficient thoroughness. But nevertheless, we are where we are. So I think there's 5 main issues to think about here from a EPC contractor's risk perspective. Firstly, let's consider those between the EPC contractor and his subcontractors and vendors. As Carl mentioned, from the case scenario, there's a 3-week critical delay on the main pumps that was existing before they closed the site. The pump vendor has already declared force majeure and seems to have documented that and established a case because of closure of his factory. So when we look at it in the round, it looks from an EPC contractor's perspective under the EPC contract that is probably liable for that 3-week delay. And then there's going to be the further delay as a result of the force majeure, subject to what Alex has to say about the relationship between the vendor's purchase order and the EPC contract, which is an issue to consider. We then come to the structural steel subcontractor. Now, as Carl mentioned, he's basically free issuing is the EPC contract to his erection subcontractor. He's procuring fabricated steel members from somewhere in Europe. The progress at site in March, they were supposed to have started, but they haven't started. There was an evident delay. And it looks as if the EPC contractor is going to be liable for the delays to that structural steel work on the basis that he's not delivered it to his fabricator. And that's going to be, again, something that we have to look at from a legal contractual point of view, but practically it hasn't happened. The EPC contractor might be able to hold the steelwork fabricator liable, but if there's a genuine force majeure in India, then that fabricator may be off the hook. And again, it'd be interesting to see what Alex has to say about this chain of command through the different contracts regarding force majeure and its applicability. So does a force majeure in India apply to an EPC contract somewhere in Europe? Interesting question that we're looking to see what the answer is. There's nothing really in the case scenario indicating that the late structural steel erection is causing a critical delay. But if that does become critical, then it's going to be a bit difficult for the contractor to avoid some liability here, because he's clearly got a problem. So let's turn to the Asian partner not being able to mobilize his team. So for whatever reason, that partner was going to be providing a team starting sometime in March to come onto site to take part in the site management. He's not been able to do that. He's been prevented from mobilizing people because of the situation in his country. But it's a joint venture, and under the contract with the client, it's almost certain that that will be under joint and several liability. So it's not the Asian partner it's not the contractor that's been delayed, prevented, it's the partner. And therefore, under that joint and several liability, the contractor probably has no excuse for this at all. I'd be interested to see what Alex has to say about it in due course. I think that the real challenge for the EPC contractor is going to be restarting the works. He's got to get his subcontractors and the vendors to resume work and deliver materials and equipment, etc. And he's got to get that in line with whatever rescheduling he agrees with the owner, which will have to take place in any case. Now, he may have some unpaid money with the subcontractors, performance bonds, etc. But really, he's not got an awful lot of leverage with the vendors in the situation that he finds himself in. He might decide that he can terminate some of these subcontractors if they're not willing to come to reasonable terms with him to enable to get the project restarted. But that's not really going to be a practical proposition, because as soon as the client says, let's go and restart, and they agree terms, then mobilization of the contractors is going to have to be pretty quick, and there won't be time to renegotiate contract terms. And there's unlikely to be any cost saving in it, because it just doesn't happen like that. You won't find people that's in a situation like this that's prepared to offer a cheap price. Unlikely, and if they do, they won't be very reliable anyway. So we come to the fourth point. Has the EPC contractor got any leverage over the owner in terms of the terms for restarting the job? Now, he may believe that he's got leverage, particularly with regard to the completion of the works and the terms relating to that. However, whatever Alex has to say about the contractual and legal considerations, the EPC contractor may find that he's got very little room for negotiation with the owner, because he's probably prejudiced his position by taking the action that he did with regard to closing the site. And the last issue is the damage to the relationships. And by closing the site, the EPC contractor may have spoiled any goodwill that might have existed between the subcontractors and vendors and itself. It looks as though the owner-employer contractor relationship is likely to have been damaged. And these two factors alone are likely to make any discussions regarding recommencement of the work and the associated terms with that a bit more challenging than there would have been had the contractor taken somewhat different actions. Does that answer your questions?
Yeah, good. Thanks, John. So I have a question for Alex, but before we do the question for Alex, I'd like Wayne, I wonder if you could bring up the third poll for me, please. No, not that poll, Wayne. The one after that one. Do you remember that thing I said about Wayne making me look good? Right. Okay. So I would be interested if you could take a quick look at this poll here. So I'm interested to know what strategy do you think would be appropriate for the EPC contractor to take with the owner? Just one of these, please. So asserting contractual legal rights, preparing for dispute, wait for the owner's reaction to the site closure, engage with the owner to explore possible solutions, reopen the site and continue with the work, or offer to recommence the work and set out the terms for doing so. Sorry, that should say at the end, for doing so. So Wayne, if you just give them a moment just to, when we think we've got the majority of the 74 people here today, thank you all for attending. When we think we've got a large percentage of those people up, perhaps you could post the results, and then I'm going to quickly take a note down of what they are. Okay, let's take a look at those and just hold that up there for me for a moment. Okie dokie. Well, writing down the answers to the first two are easy, right? 88% think we should be engaging with the owner to explore possible solutions. Only 2% think we should be reopening the site, and 10% offer to recommence the work and set out the terms for doing so. Okay, excellent. Wayne, if you could take that poll down for me. And so, Alex, let's ask you, what does the contractual legal situation look like for the EPC contractor then, from your perspective?
Well, I think we can sum it up as being not particularly good. And I'm happy to see in the poll just there that we have some very pragmatic people with us today. And I think 0% was scored for legal and contractual positions being taken, which I think is entirely right. And if we run through the EPC contractors' problems, we see that they are various and numerous. I'll consider these from two basic perspectives. The EPC contractor has contractual relationships with parties up the stream and down the stream. So it has an EPC contract with the owner, and it will have a number of subcontracts and purchase orders with subcontractors and vendors. Now, basically, in this situation, if the EPC contractor doesn't have the rights under those contracts to close the site in the way that it has done so, or it hasn't exercised the rights in accordance with those contracts, then simply the EPC contractor will find itself in breach of its contracts both upstream and downstream. If we take the upstream contract first, the EPC contract with the owner, contracts usually will allow a contractor to suspend performance of the works in certain specific situations only, for example, where they haven't been paid or if a force majeure event has occurred. Otherwise, it's for the contractor to carry out the works, and they are obliged to do so, but also they're entitled to do that. They are given possession of the site in order to do that. Now, it seems in our scenario, the EPC contractor gave no warnings, gave no notices, so it's likely that they haven't engaged one of the processes under the contract that properly permits the suspension of works in this case. Closing the site in circumstances where they have no entitlement to do so is a breach of contract, and in principle the owner would be entitled to damages for that breach. In addition, the EPC contractor is probably at risk under several parts of the contract. It may have been said to have abandoned the works or failed to proceed regularly and diligently with those works. An abandonment of the works usually entitles the owner to terminate the contract. Contract will allow a cure period commonly in which the party who is in default can attempt to rectify the situation before termination occurs. Now, if that right is available here, the EPC contractor would be well advised to reopen the site without delay in order to avoid that. There's a potential and even more serious consequence, which is a repudiation of the contract. If the owner accepts the repudiation, i.e. the contractor's refusal to carry out the work in effect, then the EPC contract is terminated. But here the owner is entitled to claim the full measure of its damages, including the damages for losing the contract. Now, those can include very substantial sums such as lost profits. Furthermore, the owner could draw its performance bonds. That would have a substantial impact financially on the EPC contractor. But even if the contract isn't terminated, then there's probably going to be critical delay once the works are recommenced, and the EPC contractor will be liable for that delay, which means liquidated damages and also having to bear its own costs of attempting to recover the delay or accelerate the work. And there's unlikely in this situation to be any opportunity for the EPC contractor to make its own claim for financial compensation. So pretty bad. In the downstream contracts, the subcontracts and purchase orders, again, depending on what those contracts say, the EPC contractor closing the site is likely to be a breach of the contract. It's an act that prevents the subcontractors and prevents the suppliers from entering the site to carry out their work. And acts of prevention, subject to the terms of the contract, will usually entitle the party that's been affected to an extension of time and to financial compensation. So this means that the subcontractors and the vendors will likely be in the position where they are relieved from their liability for liquidated damages, relieved from the obligation to complete the works by the completion date, and entitled to claim their financial losses that result from the EPC contractor's actions. Now, this could include delay and disruption costs, such as prolongation costs. Even without those provisions in the contract, under English law, an act of prevention has the effect of putting the time at large, which is to say that the party is relieved from the obligation to complete the works by any completion date and must do so within a reasonable time. And that's known as the prevention principle. In addition to those quite significant problems, there are some further complications for the EPC contractor. We know that there are some pre-existing delays. The pumps are late. The vendor appears to have notified force majeure, safeguarded its position against the EPC contractor. Structural steelwork issues, there could be a force majeure position there, but it's very uncertain. And in terms of construction execution, we know that there are issues with mobilization of personnel. So looking at the pumps and the structural steelwork, well, the EPC contractor is probably liable for that critical delay because it appears that there's no declared force majeure under the EPC contract. And even if the EPC contractor had done that, there's no guarantee that the situation with the structural steelwork would qualify as force majeure because the cause of it is remote. The lack of evidence of force majeure actually occurring is not clear, and there could be legal jurisdictions that differ under those various contracts. And with the pump supplier, even if there is a force majeure provision in the EPC contract, it seems that under the purchase order between the pump supplier and the EPC contractor, those are likely to be on very different terms. And so there might not be an equivalence of force majeure under both contracts. And those two contracts are also probably governed by different legal jurisdictions, which can influence whether there is a force majeure under the EPC contract. And we should note that some civil jurisdictions impose their own thresholds on force majeure events that might apply in addition to any contract terms. As John has mentioned, the deferred mobilization of the Asian joint venture partners' site supervision is probably not force majeure because those joint venture partners will be under an obligation to each other and they'll have joint and several liability. And any one of these three EPC contractors ought to be able to mitigate the effect of the lack of supervision. And there's also the 3-week delay to progress, which is in the case study being reported in February 2020. So before the government said anything about COVID-19, but not necessarily before the EPC contractor appointed the pump vendor. It's not clear whether the pump vendor's force majeure is responsible for some or all of the 3-week delay, or whether there's another reason for the delay. So in principle, the EPC contractor is liable for that delay until it's proven otherwise. And this part of the facts raises the issue of concurrent delay, which is where one delay, which is a delay event which is the contractor's responsibility, occurs concurrently with an event for which the contractor is entitled to an extension of time. Under English law, the basic proposition is that the contractor receives the benefit of the concurrent delay, so it gets an extension of time. However, contracts can modify that position. So it's really worth checking the contract as to what it says about concurrent delay. And this could have quite serious implications on any claim for force majeure if the contractor was already in delay to an extent. Simply, we don't know enough based on the case study, but it's not safe to assume that just because there's a force majeure event, the contractor gets the extension of time for it. If the contractor's already in delay, the reasons for those delays need to be clear, and the contract and how it treats concurrent delay is a very important factor to assess. And from a contractor's point of view, there could be an opportunity here to try and conflate the delay of its own making with that of the force majeure resulting from COVID-19 to try and get some extension of time that it might not otherwise receive. Contractors have been known to do such wily things. So owners also need to be alive to those issues. Finally, I'm just going to address change in law, because on the facts, this is suggested, but under the EPC contract, it seems unlikely because the governing law applicable there, the government in charge of that country has acted in conformity with the existing emergency powers rather than by implementing any new or different legislation. And in terms of the Asian joint venture partners, the government decree in that home country probably isn't a force majeure under the EPC contract.
Great, thanks, Alex. So listening to that from both sides, seems like based on the information available in the case study, you know, the situation in the longer term does not look good for the EPC contractor.
I think that about sums it up, yes.
All right, good, I'm keeping up then. All right, excellent. All right then, John, by the way, guys, I realize we're running a little bit tight on time, so just to let you know. But so John, let's consider the situation from the owner's perspective then. How do you think the EPC contractor's action will have been received? That's one question. And then what are the likely consequences for the owner and how might it respond to these?
Yeah, good question. I think that the starting point is the importance of relationships. And I can't really emphasize that enough. If you think about it, an enlightened owner in this situation may have been empathetic towards the EPC contractor and the situation that it was in. But the action the EPC contractor took and the way that it did it without consultation even can only leave the owner feeling somewhat aggrieved. The EPC contractor's action, however, does point to a sort of cool relationship between the two parties prior to COVID-19 affecting the job. But unilaterally closing the job down, even if that wasn't a great relationship, can't have helped things very much. So I think that, you know, the way that we affect relationships in any difficult situation is really quite important, particularly when we're trying to get it ultimately to a solution. So if we turn to the main consequences for the owner, I think the first thing is the owner must feel that he's lost complete control of this project. And I'm not going to deal with the contractual and legal issues, which Alex will come to shortly. But the owner's facing a huge amount of uncertainty regarding the future developments and when his project is going to be continued and completed and then operational. And probably the owner could be confronted with three main potential consequences. The first is a hindrance or prevention in meeting his own contractual obligations. So I think we have to think about that the owner will have undoubtedly made legally binding commitments to bring the extended plant into operation in order to service local community requirements. It just makes sense to me that that's going to be the situation. The owner may also have made commitments, whether they're legally binding or not, and directly or indirectly to organisations that are developing other projects and are reliant upon this project for their own use. So they've committed to their projects and are reliant on this plant being operational. And therefore, depending upon the extent of the delay and any time contingency allowances that the owner has made, the chances are that the project is going to be delayed and he's not going to be able to meet his contractual commitments and these other commitments. And that then may have an impact on the owner. The business case that justified and supported the financing package may have to be renegotiated because it's impacted due to that delay. The owner may have commitments to the operation and maintenance obligations when the project's finished. And again, depending on the extent of the delay, they may have to reschedule and renegotiate that lot. And then with a plant like this, there may also be items of equipment that the owner itself is supplying that fit into the EPC contractor's delivery. And of course, if there's major delay where that equipment can't be accommodated due to the contractor being behind, then those are going to have to be renegotiated. And all of those mean probably there's going to cost the owner more money. We then come into a less practical area, but nevertheless fairly important, and that is the political, public relations and reputational damage that the owner may suffer. Firstly, the authorization and need for a project of this kind was probably politically driven, either locally or regionally or even nationally. And those problems that are now facing the project can quickly become really political because it's a big plant, it's sitting there and nothing's happening. And infrastructure projects always have their detractors everywhere, the NIMBYs, not in my backyard brigade, in the public arena, who are usually fairly noisy. And when they see a perceived problem with the project, then it's, here's another failing infrastructure project that we can have a go at. And that's the likely mantra, because it's what happens. And in that context, there's nothing worse than a major project sitting idle, partially completed, to attract public and media attention and for people to speculate as to what has happened, what's going to happen, etc. And none of that is helpful to an owner, and it can get quite difficult. Because the utilities industry often receives quite bad press. You know, allegations of overcharging coupled with poor and inadequate service. And so a stopped project could simply add to existing criticism of an owner and just no empathy for the situation at all. And the press just gets worse. So then you start with a debate about the viability of the project. Because the experts are usually the ones that know nothing about the project at all, or the circumstances, but can speculate at length on various hypotheses. But as soon as the press get hold of it, of course, the owner has to deal with it, and it's just a distraction from the main problem, which is how on earth am I going to finish this project? And then we come to the third issue, which are corporate issues. And the longer the site remains closed and the uncertainty regarding completion and plant operation remains, the more this becomes a subject for public debate, then the greater the damage to the owner, both financially, reputationally, and in terms of shareholder values. Public quoted company, and the real bad press can have an impact. So, given those circumstances, then the owner's primary objective most likely will be to get the project restarted, completed as soon as possible. And while its contractual and legal position opposite the contractor might be robust, and Alex may have something to say about this, I'm sure, the owner will be entirely reliant upon the contractor and his subcontractors to get the project finished. So he's going to need a strategy, and it needs to be well thought through. And that might require some real lateral thinking, given the situation, the circumstances that he's confronted with. And he's got a bit of a challenge because he'll want to do two things. Avoid the EPC contractor from leveraging the situation. And the EPC contractor may consider, to start with, he's got some leverage. And secondly, he needs to secure the EPC contractor's full commitment to achieve what the owner requires in terms of project completion. These two things are complete opposites, and yet you've got to find a way as the owner for bridging them. So he's going to have to make some difficult decisions. and take actions that, from an emotional point of view, and dare we talk about emotions in the context of major civil projects, it could be quite difficult, because he's going to have to safeguard his interests, but at the same time, there may be resistance in his own organisation to committing additional payment to the EPC contractor, given what he's done and the situation that they're in. But you have to step back and be realistic. Is the amount of money that you have to pay to look at your longer term interest an investment, and rather small compared to your interest not being fully satisfied? And while all this is going on, he has to continue to manage the situation. He has to continue to deal with the public situation. And all of this is going to require some fairly significant leadership on the owner's side. So I think that's the picture that I see from an owner's perspective, Carl.
Okay, so back to you then, Alex. And I just want to again remind you both, time is our enemy, unfortunately, so we just need to keep abreast of time here. Alex, what does a contractual legal situation look like for the owner then, from your perspective?
Well, the owner is in actually not a bad position at all, legally and contractually. We've seen that the EPC contractor has breached numerous provisions that gives rise to numerous entitlements for the owner. But unfortunately, I don't think any of those legal and contractual rights are particularly good practical solutions to this problem. In my experience, disputes generally don't get projects completed on time, and that is the real problem here. The problem for the owner is a commercial one, because the longer the project is delayed, the less chance it has to generate revenue. So what the owner decides to do legally and contractually may affect how severe the project delay is. So legally and contractually, it's in a fairly strong position. It needs to pay attention to protecting its position. We know that the EPC contractor closing the site is probably a breach of the contract, and that gives rise to certain rights. I've touched on these already. One is to terminate the contract, either under the contract's terms, or if there's a repudiation, to accept the repudiation. Both of those strategies are risky. Termination under a contract is risky, whereas repudiation is substantially even more risky. So, as an example, an incorrect termination of a contract based on a repudiatory breach argument, if it fails or goes wrong, can itself be in a repudiatory breach of contract. So the owner could go from being in a pretty good position to being in a very bad one if it takes the wrong step strategically. In the case study, we don't know if the EPC contractor's closure of the site was intended to be temporary or permanent. There is a rumor that the EPC contractor plans to reopen the site. So if that's correct, termination could be an overly drastic step to take, and it may create more problems than it solves. So the owner really has to consider termination quite carefully. And also, it doesn't seem to me this is a good time to be upsetting contractors. In the world in which we live, things will still need to get built. And so an owner will have to accept that even replacing the contractor could have some issues, because all contractors will face the same problems of working through the pandemic. The owner could draw the performance bonds, but again, this is a very divisive step to take. And if those bonds are on demand, then that's good. But again, this is a drastic consequence. And if the contract's not terminated, then liquidated damages are, of course, the owner's option to claim for the period of delay as and when the works may restart. The owner does have to mitigate its losses. Contracts usually contain a duty to mitigate. Even if they don't, then English law says there is a duty on a party to mitigate its losses that arise from a breach of contract. So the owner needs to assess its mitigation strategy. That might well be replacing the contractor, or it might be re-engaging with the existing contractor to see if they are prepared to recommence the works, and if so, how soon and what safeguards will be in place to do so. So to summarize, really, there are legal options there, but they're not really good practical ones. And so I go back to the poll earlier on, and all of the pragmatic 88% of people are on the right lines here. I think the real crunch for the owner is to decide whether it stays with the defaulting contractor or finds a replacement. And there are many variables and drivers behind such a decision, and that requires quite detailed and careful analysis.
Great, thanks, Alex. Okay, moving swiftly on. Let's take a look at the structural steelwork erection there, the subcontractor's perspective. So, John, let's start with you. And how do you think the EPC contractor's action to close the site will have affected the subcontractor here? And what are the likely consequences for the subcontractor? And how might it respond to these? And as before, John, briefly as you can, please. Thank you.
I mean, we've established that before the closure of the site, there was a pre-existing delay for the installation of structural steel. And so we have to recognise that situation. The closure of the site effectively meant that the structural steel subcontractor was prevented from continuing with the work. So it depends really what had happened in preparation to commence the structural steel erection in mid-March 2020, according to the plan. And if the subcontractor had mobilised and was ready with equipment and ready to put people on the job for a mid-March start, then the closure of the site meant basically he's got his equipment sat on site. He can't use it, he can't deliver steel, he's going to be incurring cost, and what's he going to do with the resources? So he's put into a very difficult situation. And, you know, subject to what you're going to say, Alex, it looks like he may have a reasonably good case against the EPC contractor. The steel was supposed to be free issued and it hadn't been issued. And it looks as though the EPC contractor is going to struggle to get that steel to him very quickly, even if the site was reopened, you know, expeditiously. If the structural steel subcontractor hadn't actually mobilised and the EPC contractor was to say, well, you were late anyway, it becomes a bit of a difficult argument for the EPC contractor to sustain, and probably relatively easy for the structural steel contractor to say, I'm sorry, but you know, you gave me no opportunity to get on with the work, whether I was late or not before you closed the site. The effect of your closure has completely overtaken any other events. And by the way, you still haven't delivered the prefabricated units. So I think that the structural steel contractor, his biggest problem is going to be getting paid for the costs that he incurs as a result of waiting for the time when he can actually get on and do the job with the prefabricated units and access to the site. I think that's the situation for that steelwork contractor.
Great, thanks for that, John. So again, back to you then, Alex. You know, what does it look like from the contractual legal situation here for the subcontractors, but in particular, you know, the steelwork erection subcontractor?
Yeah, really, again, they're in a fairly good position. As we've touched on already, there'll likely be an entitlement to be relieved from liquidated damages, relieved from performance to complete by the contractual completion date, i.e. extension of time, to claim their losses from the EPC contractor, which could include for delay and disruption, because they're being prevented from carrying out their work. So what those subcontractors need to do is to make sure that they protect their position by following all of the procedures in the contract for notifying a claim or for giving an early warning. Anything procedural that needs to be done, and they must do it within the time limits and in the form set out. Because the worst thing would be if they failed on an entitlement simply because they failed to submit notices on time. That's not a good position to be in. They also need to mitigate their losses, so focus on any downstream contracts that they may have. Absolutely do not do the same thing that the EPC contractor did, which is to unilaterally declare the site closed. This needs to be framed as a force majeure event, because downstream the subcontractors don't want to put themselves in the same unenviable position as the EPC contractor. So with regard to the structural steelwork contractor, they are being delayed, it seems, by compounded issues of both the fact that there's no steel, and even if there was steel, they can't get onto the site anyway. So pretty tough position. There could be some concurrent delay issues, but both of those events are not the structural steel contractors' fault, and what they should be monitoring quite carefully is what they are incurring in terms of cost. Even though they're local to the site, there could be some costs being incurred, and those will be the responsibility of the EPC contractor. And so my final point is really that they should be keeping records of those expenditure items and keep records of the facts that link the losses to the EPC contractor's breach of contract, because in any future claims, those subcontractors will need to show that the EPC contractor's breach caused the loss. And so the better the records that they have, and the more records that they have, the more straightforward those claims will be.
Super, thank you. So I guess we have just got time, I think, to cover the John. So let's talk about the main pumps vendor and the structural steelwork fabrication vendor. So, you know, what is the situation from the perspective of both of those, and how do you think that the EPC contractor's action to close a site has affected them? You know, what are the consequences for the vendors? How might they respond?
Well, as we know, there's already a 3-week delay to the pumps at the time that COVID-19 affected the site. Now, we don't know the reason from the case scenario for the 3-week delay. And from a vendor's perspective, it's essential to establish the reason for the late delivery and responsibility for it. And it's really, is it the vendor or is it the EPC contractor? That's the decision that's got to be made. And that's important because it's going to affect how the vendor actually proceeds. Now, the force majeure, we know that the vendor has declared a force majeure as a result of COVID-19 closing his factory. But that isn't as straightforward as it really looks, because we're not sure from the case scenario the dates of that declaration of the factory closure. And these need to be established because they could be quite influential. For example, if the force majeure declaration preceded the site closure, then so long as the delay effect of the force majeure continues and ends beyond the date for which the site is reopened, the cause of delay to the vendor would be entirely force majeure. So he's already protected his position and he's okay with that. It's no help to the EPC contractor, incidentally. But if the force majeure declaration is after the EPC contractor closed the site, and the effect, the delay effect of that ends before the site is reopened, then the force majeure may have no effect on the pump delivery because deliveries cannot be made until the site is open. And there could be very many permutations depending upon when the dates are for the closure of the plant, when the deliveries can be made, etc. And therefore, it's really important to understand exactly what happened and when it happened before you can make any decisions from the pump vendor point of view as to their actual position and entitlements. Of course, they will have incurred costs, no doubt, which they will want to be able to pick up from the EPC contractor. But that might be a little bit difficult. I think the pump vendor will be really well advised to set out its position in writing to the EPC contractor in conformity with whatever the purchase order relevant terms and conditions are. And I think you'll say a bit more about that, Alex, in a minute. From the structural steel prefabrication vendor point of view, there's not a lot of information about the status in mid-March of the steelwork deliveries from India to the prefabrication yard. And there's no information about the status of the prefabricated units, if anything was being prefabricated or not, depending on those deliveries. And therefore, establishing the facts in these respects is absolutely crucial from that fabricator's point of view, because the EPC contractor may or may not have some liability there. There could be delays to prefabrication which is caused by EPC detailed design or whatever, and it's really about establishing those facts to know where we stand. And in the case scenario, we don't have enough information for that. And then there's the question of cross-border force majeure and multi-legal jurisdiction regarding force majeure and how it's operated. And I think, Alex, you're going to talk about that a little bit, aren't you?
Yeah. So thanks, John. So again, then, Alex, finally, what's the contractual legal situation? What does that look like for the vendors and suppliers?
Well, they'll be in a different position to the parties who are upstream of them in the contractual chain. Their purchase orders or subcontracts are likely to ring fence their risk based on their scope of supply. So they don't have the same concerns as the parties higher up the chain. Their remit is more limited, and their primary concern is whether they'll be paid on time, particularly where they're supplying long lead items or high value items that are already in the process of being manufactured specifically for this project. And John has identified some of the short-term costs, such as storage and demurrage, if those things can't be delivered as planned. So they'll need to check their contract terms to ensure that they can effect delivery in accordance with the requirements and avoid incurring those additional costs. Generally, I've seen that smaller businesses tend to be more affected by COVID-19 because maybe they only have one factory. It's harder for them to remain open, etc., etc. They need to check the force majeure provisions. We've touched on that quite a lot today. I will quickly mention frustration. If contracts don't contain force majeure provisions, then there may be a case to say that the contract has been frustrated by the impacts of COVID-19. Frustration occurs if performance of a contract becomes impossible or illegal, or if an event happens that transforms the obligations under the contract into something completely different. Frustration has the effect of discharging a contract, which means parties are no longer bound to perform their obligations. The event must be one that's neither party's fault, and it must be so fundamental that it strikes the root of the contract, as the law says, and goes beyond what the parties were contemplating. So it's quite a high bar to clear, but it's useful to consider if there's no force majeure clause. There are some construction cases from wartime where contracts were frustrated because construction work was illegal to carry out during a war, for example. So it seems possible to me that COVID-19 related circumstances could frustrate a contract. The local law that applies to the contract could also give some help to these vendors, because some civil jurisdictions have hardship provisions that allow a contract to be terminated or renegotiated if there's a change of circumstances such as this that affects the economic basis upon which the contract was made, including where performing the contract becomes less profitable for a party. In terms of the pump vendor, they seem to have done all the right things. They seem to have protected their position via force majeure. The structural steel vendor situation is less clear. They've declared force majeure under the purchase order, but they haven't given any indication as to how manufacture has been affected. But the key point here is it's not sufficient just to say that there's a pandemic. There has to have been some causal impact on their ability to conform with the contract. So if the government shuts their factory and they only have one factory, that's a pretty good force majeure argument. It's not a good force majeure argument if it simply becomes more difficult to manufacture. The cross-border issues that John referred to, you can see in this case study, we have a network of contracts. Parties are based all around the world. The project is in Europe. Some of the parties are elsewhere. Each of those contracts will be on different terms. Each of the contracts are also likely to have different laws that govern them. So given the way the COVID-19 pandemic has affected different jurisdictions at different times, and that governments have responded to it in different ways with varying levels of competence, shall we say, it's not the case that just because one party in the chain has got a force majeure event under its contract, that the other parties in the chain do as well. So just because one party has a force majeure event, that may be another party's contractual risk. You see that with the relationship between the structural steel contractor and the EPC contractor. So these things require quite careful assessment and management to work out what is best strategically.
Great, super. And I did mention early on that time is our enemy, and we are out of time. So I want to make a kind of apology here to Osgur and Vikas and the others who have sent questions in. So we'd like to, I think we ought to get back on those questions. If there are people out there that have questions and want to send them in either to me or to John or to Alex, then we can coordinate that, and perhaps we'll, if there's just a small number of questions, we'll send that back out as an email. If there are a few more, then I'll probably hold my two experts here down to perhaps coming back together with a glass of wine and recording a Skype chat or something to get those answers back out. Thank you again for joining us. In a few days' time, this webinar should be up on our YouTube channel and also hopefully up on Freeths channel as well, so you can direct colleagues to that. I do hope you're able to make it for the second webinar in the series, which is about making and defending claims as a result of this. That's on the 14th, it's not the 14th, it's on the 21st of this month, because this is the 14th. So that's on the 21st, next Thursday. We'd really like to see you there, and watch out for our website and emails for answers to those questions. Thank you, John. Thank you, Alex. I appreciate that was a challenging amount of material to get in within time. Wayne, thank you in the background as ever. And thanks, and we'll see you next week, hopefully.
All the best, everybody. Bye.